We're ready when you are. Good morning.
May it please the court, I am Nick Piernick. I represent the appellant Sabrina M, or Sabrina C, I'm sorry, in this matter. Talk with Ms. Summers, who represents the father.
Do you want to save any time for rebuttal?
Excuse me, Your Honor?
Do you want to save any time for rebuttal?
I'll save 3 minutes for rebuttal.
Yes, sir. Thank you.
Are you
Okay.
are you all splitting
We
time?
are not splitting. Ms. Summers believes the brief is sufficient for her argument.
Very good.
Some of my argument will touch on that, especially on the grounds.
We note that she's here and glad she's here, and we have read the briefs. Thank you.
Thank you, Your Honor. So I represent Sabrina C in this case. This is a termination of parental rights case. As to the mother, there were 4 grounds found against her. DCS has conceded 2 of those grounds and is moving forward, stating that termination of parental rights is valid on the grounds of severe abuse and willingness and ability of a parent. The severe abuse ground is the first one I want to address. A recent case in Re Dakari came out 2 weeks ago from the Supreme Court clarifying termination of parental rights on severe abuse. There are 2 cases, in Re Dakari from 2023 and in Re MJB from 2004 that talk about the severe abuse and what needs to be found. So for dependence neglect, a child can be found to be dependent and neglected if he or she is severely abused. However, in a termination of parental rights, in order to terminate a parent's rights to a child, the court must find that that parent was the perpetrator of severe abuse or failed to protect the child from severe abuse. In Re Dakari, decided a few weeks ago, there were similarities to this case. In that case, there were 4 possible people who had contact with Marcus.
Well, did the trial court here make an independent determination of severe abuse against the mother, or did the trial court rely on the prior order in the dependency neglect case?
Right. Marcus did not rely on a prior order.
Well,
it was tried proven in that
Right.
case. In this case, there's a prior order. Now, in Marcus E., there were 4 possible perpetrators, and the court in that case identified the parents as perpetrators. The Supreme Court said, based upon the evidence, we could not find out who did it or who didn't do it. And you have to have a perpetrator. In the case at bar, the court on the dependence neglect side did not identify a perpetrator. That is a prong that must be satisfied. The court said, we cannot exclude the parents. Similar case, there were mother, father, father's paramour, and a babysitter.
So was the dependency neglect order a final order? Did res judicata apply?
Well, there's 2 grounds. One is that we don't have a perpetrator, so that can't be used. The second is whether or not that order finding severe abuse was a final order. It was not. It states clearly in the order from the magistrate, it's set for disposition. And for dependence neglect cases, under TCA 37-1-159, a dependent neglect case is not final until there's a disposition. The court specifically said in the order as to Dakari M, we find severe abuse, we cannot identify a perpetrator, the parents can't be excluded, and this case is set for disposition the following week. There was no further order entered by DCS regarding disposition.
So in this case, did the court make its own determination of severe abuse? Or did it just say, I've got this prior order, adjudicatory order, which you say is non-final, and that's enough?
That's what the court in this case did. So I've got a prior order finding severe abuse, but ignored the MJB, which says you have to have a perpetrator as well as Marcus E, and did not determine that there was in fact a perpetrator. In order to terminate parental rights, you've got to prove that the parent was a perpetrator. If the final order had said the mother perpetrated the abuse and the father failed to protect, or vice versa, and it was a final order, then the court terminating parental rights could have relied on it. In this case, whether it's the department not entering an order of disposition or disposition never actually happening and that case still remaining open, we don't have proof that it was, one, a final order, or two, that there was a perpetrator. So I believe that that ground cannot be relied upon for termination of parental rights.
So turning to the failure to manifest ground here, one of the complaints made is that the court didn't say what the substantial harm was here.
Right. So on the ground of willingness, failure to manifest a willingness and ability, frankly, the trial court is asking this court to go back and retry the case. The court found only one item as far as the substantial risk, which was that Dakari M had a strong relationship with his foster family, and that it would be devastating for him to be removed from that foster family, and that was a substantial risk of harm as to the mother returning custody. And the other cases that you see, a lot of them touch on the psychological issues with the parents' bond with the foster family. But that's not the only thing. If you only have child bonding with the foster family, then what's DCS's goal? Keep this child in foster care for a while, then terminate parental rights based on a willingness and ability, because we can just show a psychological harm. The other cases, the appellate court cases, clearly show that something else is needed. In many cases, in the case of Noah B., that the child's contact with mother would re-trigger the trauma. In the case of Nevea S., which is the Supreme Court case, beyond the psychological harm, the mother was not visiting. The mother was testing positive for drugs, and the child didn't even know the mother. In another case, in Re BDM, the father, besides psychological harm, the father had schizophrenia and was not treating himself. We do not have any of those factors in this case. When you look at the mother, her permanency plan, which says these are the things you need to correct, she had corrected all of those by the time of the trial. She had housing. She had treating her mental health. The court in here made findings that the mother tested positive for marijuana 3 years prior to the trial. That is not relevant. The court also found that the mother had pending criminal charges. That was not proven in the trial. A lot of the facts that are in the opinion are not supported by a preponderance of the evidence. DCS relies to try to boost up this willingness and ability and this risk of abuse to say that the mother had drug issues. There was a drug assessment from 2017, or a parenting assessment from 2017. There was the court's findings that the mother tested positive in 2019. The case manager testified, I'm not aware of mother ever failing a drug screen, at least as long as she's had this case. So drugs were not an issue. The department purports that domestic violence was an issue, and yes, it was an issue early in the relationship. There were domestic violence issues, but the last domestic violence issue, according to the testimony, was 2017 or 2018, 4 years before the trial took place. Mother, since then, had got on the bandwagon, taken domestic violence classes and therapy, and separated herself from the father. While it's true the mother was assisting the father even up until the time of trial, the mother lived on her own at the Salvation Army in a shelter for single parents and children where the child could reside. She did provide the father, he had some serious mental health issues and some serious stability issues with some housing, paying for a hotel room now and then for him, and also made sure that he got his medications, so in her terms, he would stay alive. He needed them to survive. The department seeks to use that against her and say, well, you're obviously still in a relationship with him. Other than that, there was no evidence of a continued relationship that would be harmful to Dakari M. Finally, they use housing instability along with that, saying that mother was maybe with father. The only evidence was mother had been in the Salvation Army for a year, and that it was appropriate for mother and the children. She was working a job at that time and on the list to get into housing. Unfortunately, as the evidence showed, that prior to that, she had her own house, but the tornado in 2020 came and blew it down, and the folks did not let her move back in after it came. As you can tell, the redevelopment here in Nashville, once places are blown down, they're built up and sold for millions. So the mother had that. It also talked about criminal activity. The department states that criminal activity would be an issue. The court did find that the mother had pending criminal charges. And in my review of the testimony and evidence, the mother did in fact serve some jail time in 2019. But there was no testimony of any pending criminal charges. In fact, one of her items on the permanency plan was to clear everything up. And that's what she did. So the court's finding that there were pending criminal charges is not supported by any of the evidence. There were some current charges, but they were against the father and another woman, not between the father, even between the father and the mother, and certainly not against the mother. So the willingness and ability ground is not supported by the evidence. Either willingness, mother said she wanted a kid back, she had done her permanency plan and shown that she had made progress. Ability, she had a place for the child to stay, the child was able to live there. She had a full-time job, and then substantial risk of harm. Court's finding was only that the child was bonded to foster parents, and that there were no other factors proven by a preponderance of the evidence. As far as best interest, I think that the brief covers best interest for the most part. The court in this case, trial court, is once again requesting that you review the complete thing, because out of the 20 factors that are in the code, the court addressed 7 of them, and addressed most of them in 2 sentences or less. So this is a difficulty, and as you look through those factors, and a lot of those factors have to do, has the mother righted her ship? She had at the time of trial. She had righted her ship, and she had been stable and able to take care of the child for a long period of time. So we would submit that there was not grounds underneath severe abuse or willingness and ability, and it was not in the child's best interest for rights to be terminated.
Thank you, Mr. Perenick. We'll hear from you further on rebuttal. We'll now hear from the appellee. Good morning.
Good morning, Your Honors. May it please the Court, Catherine Adams with the Tennessee Attorney General's Office representing the Appellee Department of Children's Services. This case is ultimately about Dakari Mensa, who is a 9-year-old boy who has been in DCS custody since late 2016. This court should affirm the termination of mother and father's parental rights to Dakari, as the trial court properly found 2 issues in this case. Number 1, grounds to terminate mother and father's parental rights, and that termination of mother and father's parental rights was in the best interest of Dakari. I'm just going to jump right into severe abuse, as I believe that's what the appellant spent a good bit of time on. In reviewing Re Marcus E., which Your Honors touched on a little bit in questioning earlier, I believe that Re Marcus E. is distinguishable from this case specifically because the trial court in this case did not make an independent finding of severe abuse and focused only on res judicata, which would apply in this case.
So the court here, in its order, said the parents were adjudicated as perpetrators of severe abuse. Is that accurate?
So in the orders, there were 3 orders actually from the dependency neglect proceeding, and Dakari was found to be Dakari's sibling was found to be a severely abused child while in the custody and care of mother. If it's all right, I think to clear up any confusion, I wanted to kind of go through the 3 relevant orders from the dependency and neglect. So the first order would be from Exhibit 14, and that was the order from the dependency and neglect proceeding as to Dakari. And within this order, the juvenile court stated that it was concerned that injuries to Madison were, quote, at least the act of one person with a likely knowledge of another and the failure of that person to protect Madison. and the court found that Madison had suffered severe abuse while in the custody of mother. This is the order that at the end had further dispositional hearings needed. So that was as to Dakari. Exhibit 15 is actually the order from the dependency and neglect proceeding as to Madison, who was the severely abused child in this case. And in that order, I would just like to point the court's attention to footnote 1, which is on page 3 of that order. And that says that Dakari was found a dependent and neglected child based on the dependency and neglect and abuse of Madison perpetrated by Dakari's mother and father, the mother and father in this case. There was also Exhibit 16, which is entitled Order Clarifying Severe Abuse Finding. So Exhibit 15, which was the original order from Madison, made it very clear at the end that disposition was final. Disposition, the custody of Madison was to her father. There was no further dispositional hearings needed based on the ending of that order. Exhibit 16, the order clarifying severe abuse finding, rescinds portions of the order 15. It uses the word rescind in the last paragraph based on the title of the order, the contents of the order only focusing on the word abuse versus severe abuse. It's clear that the order was only intended to affect that specific finding as opposed to the underlying facts of Exhibit 15 or any of the other things in the order. So based on the reading of Exhibit 15 and 16, so the two orders as to Madison, Madison was found to be a severely abused child and disposition was final. It was a final order, it was appealable, and res judicata attached at that time.
So even though the 2020 order says I'm rescinding that order, that's not really what the court meant, you're saying?
It wasn't I feel like the word rescind wasn't the correct word based on everything else in that order and the way it was titled and the rest of the context. Basically, Exhibit 14 and 15, the orders for Dakari and Madison initially weren't consistent. Dakari said that Madison was found severely abused. The order for Dakari said Madison was found severely abused, and the order for Madison didn't have that word severe in it. And so to clear up any confusion, the court issued that final order, Exhibit 16.
And I'm assuming then you're saying we don't have to worry about Marcus E. here. I mean, I don't think this had it been appealed, I think the Supreme Court might have had trouble with the dependency neglect order because it really doesn't narrow down, the circumstances of the abuse here as Marcus E. seems to want us to do, but it doesn't matter, you're saying, because of res judicata.
So yeah, as far as In re Marcus E. Digging into that knowing requirement for failure to protect, I don't really think we get there. I think it's all a res judicata issue, and as they weren't appealed, it's a final finding by the court below.
And then on failure to manifest, what about the substantial harm component here? Is there enough in this order to survive our review?
So yes, as far as the record clearly shows, is replete with evidence that placing Dakari in mother or father's care would pose a risk to his physical and mental well-being. As to his mental well-being, Dakari was removed from mother and father's custody when he was 2 years old. He turned 9 this last March, and in accordance with In re M, the court can consider that a basis for being psychological damaging to the child. He has significant connections with those individuals in his foster family. He calls foster mother and father mom and dad. He has connections with his 2 older foster brothers. To remove him from that home could be psychologically devastating to Dakari. I also think the record shows an additional risk of physical harm to Dakari if he was removed to mother or father's custody. There's the severe abuse finding below in the dependency and neglect proceeding. There is a history of domestic violence between them. And father actually had a pending domestic violence charge against him at the time of trial. And importantly, mother was living in the Salvation Army, which she acknowledged in testimony. She said she would need to find like a family room or something, and the place she was currently living in the Salvation Army would not be proper housing.
Yeah, that all sounds like good proofs of substantial harm, but the judge just said, furthermore, placing the child in their legal and physical custody would pose a risk of substantial harm to the welfare of the child, period. I mean, that's all the court said. So are we just to look and say, okay, well, we can figure out, we know what the judge was thinking here? Is that what we're supposed to do?
I believe in looking through the best interest analysis in other areas of the order. There are additional findings the judge made.
That we can piece it together.
Unfortunately, I think with this order, that's probably the best course of action. I do want to go back just because I have a good bit of time to just the first element of the failure to manifest ground, which would be that the parent has failed to manifest by act or omission an ability and willingness to personally assume legal and physical custody of the child. So as to father, there's clear and convincing evidence that father failed to manifest both an ability and willingness to care for Dakari. As far as ability, father was unemployed at the time of trial and had been since shortly after Dakari entered custody over 5 years prior. He had no stable housing and was living in housing paid for by mother. And while father testified that he was in the process of appealing his SSI benefits, he had had 5 years to resolve that issue with little to no progress made. Which also goes to the willingness aspect. Father's lack of any progress in remedying his circumstances in the 5 years between Dakari's removal and the trial and the termination petition demonstrate a failure to manifest a willingness to assume custody of Dakari. Father had no positive change in employment or income stability, had pending domestic violence charges, and continued to struggle with mental and physical health. As to mother, there's also clear and convincing evidence to support the conclusion that mother failed to manifest an ability and willingness to care for Dakari. In terms of ability, at the time of trial, mother was living at Salvation Army. She acknowledged in her testimony that that would not be appropriate housing for Dakari as she was living then. While she worked regularly and made approximately $800 per week as a prep cook, approximately 5 years after Dakari entered custody, she was still living at the Salvation Army. She also testified that at least a portion of her income was going to support father, paying for his housing and medication up to a week before trial. Mother testified that she waited until the day before trial to apply to a lease for an apartment and to get on a Section 8 housing list. Which also goes to the willingness. Mother failed to manifest a willingness to assume care and custody of Dakari. Her largest obstacles to reunification with Dakari included her unstable housing and her ties to father. In addition to mother's paying for father's housing and medication, there was also testimony from 2 different caseworkers who stated that they were concerned that there was a connection between mother and father that they couldn't seem to shake. There was concern specifically by Mr. Beavers, who is a Camelot caseworker, that they were inexplicably linked and they wouldn't be able to not function kind of as a family unit. As stated, mother had still not obtained stable housing by trial and appeared to be connected to father by that testimony and by her paying for his medication and housing, which shows that there was clear and convincing evidence to support that she failed to manifest a willingness to care for Dakari. I've already covered risk of substantial harm, which would be element 2 of that ground. And if there's no more questions on grounds, I'll move into best interest.
So we have a court here that examined 7 out of 20 factors. Even in your brief, you say there's other factors here that appear to be applicable and support a best interest finding, but the court doesn't reach those. I'm assuming you're saying that's really not an error that we should worry ourselves with. Even, I mean, to me, it looked like the court was using the old factors.
So when I initially got the order, I assumed that as well, but then I went through and looked, and it's actually not number 1 through 7. It's just
Right.
pulled different factors from 20.
Yeah.
It is only 7, but that was my initial thought as well.
Yeah.
But it is pulled from the new as amended 20 factors. I believe with the findings the court did make on best interest, and with all of the evidence in the record, there's enough to meet the best interest requirement here.
Yeah.
As to, I want to step back a little bit, I'm sorry. The DNN orders, specifically the one for Dakota, you said that order still lacked the disposition. Was that ever done? And if not, was that a final order?
To be honest, I'm not sure what the further dispositional hearings were needed for Dakari were. I know that he was placed in his foster home after he was removed, and he stayed in that foster home, so there was no further physical, like he wasn't placed in any other physical custody after that. But I'm not sure exactly what further hearings were needed. That order was back, I believe, in 2017 or 18. I have the orders at my desk. I just don't have them right in front of me. But I believe for the res judicata finding, it matters whether the order of the severe abuse was final. And mother and father in this case were party to both of those proceedings, Dakari and Madison.
Okay.
With just some of the time I have left, I'd like to go through some of the best interest factors that apply. Factors C, J, and L apply in this case. Mother and father have not demonstrated continuity and stability in meeting Dakari's basic needs and have not demonstrated a lasting adjustment of their circumstances as to make it safe for Dakari to be in their homes despite reasonable efforts by DCS. Trial court found that DCS made reasonable efforts in this case, and despite these efforts, mother and father had not demonstrated a lasting adjustment of their circumstances. They still did not have suitable or stable housing. Father continued to rely on others to support him. Father had a pending domestic violence charge, and despite testifying to domestic violence issues between them in the past and attending domestic violence counseling multiple times, mother and father appeared linked by the trial court and by testifying caseworkers. Factor N applies here, as Dakari's half-sibling Madison was found to be a severely abused child while in mother's care and custody, and that finding has not been appealed. Factor S applies. At the time of trial, father had never paid any child support for Dakari since he had entered foster care. This is despite the fact that he had been ordered to pay $75 per month and testified that he understood he had an obligation to support Dakari. And finally, factors A, B, H, and I. Termination would have a positive effect on Dakari's need for stability and continuity of placement, and Dakari has created a healthy parental attachment with his foster family. He's been in the same foster home for over 6 years now, is extremely bonded to them. A change in caretakers would be detrimental to his well-being. Dakari has only had supervised visitation with mother and father since his removal in 2016. And while mother and father have fairly regularly attended supervised visitation, the record reflects these visits have not always been positive. Mother and father were frequently late. There was some instances of inappropriate behavior of the father, such as speaking on the phone during visits for a large period of time, lifting up his shirt. There was arguments between mother and father. But finally, Dakari views his foster parents as his primary caretakers, and he testified at trial that he does not want to live with mother and father, but wants to live with his foster family, as they, quote, keep him safe. All of these best interest factors in this case weigh in favor of terminating mother and father's parental rights. In conclusion, ultimately this case is about Dakari. It's about his safety, his well-being, and his stability. Respectfully, Department of Children's Services asks this court to affirm the trial court's termination of mother and father's parental rights. I'm happy to answer any additional questions the court may have.
Hearing none, thank you, General. All right, Mr. Peronich.
I heard the question about the orders in the dependence neglect case. There were 3 orders entered here. This case, there were 2 cases, Madison and Dakari, that were heard the same day, but 2 separate orders were entered. Order to Dakari stated that Madison had suffered severe abuse while in the custody of her mother, just as in Marcus A. And then the court cannot determine who specifically caused Madison's injuries. However, the court cannot exclude Sabrina C. or Dustin M. as the perpetrators. No finding that they were the perpetrators, just cannot exclude. Then there was an order as to Madison entered during that same period that found that she was not a victim that she was not severely abused, and disposing of the case as to Madison. That order, that second order, was rescinded by a later order that was an order of adjudication as to both, finding Madison was a victim was severely abused. So it's very confusing, but the second order that's actually in the file was rescinded by the trial court. And as I stated before, the first order regarding Dakari and even the third order don't mention, well, the first one does mention disposition at a later date. The third order just goes to adjudication and doesn't even mention disposition as to either child. So that case, I believe, is still open at the juvenile court.
The second order you say was rescinded, and in fairness to you, the order does say that, but then it goes on to apparently clarify what is being rescinded.
Yeah, well,
What do you say about
in the
that?
third order, it's underlined that order is rescinded. We have to assume entirety or just as to the finding of severe abuse. Even if you assume just as to that finding of severe abuse, it does take care of a disposition as to Madison's case, not as to Dakari's case. Dakari's case specifically, the first order says it will be continued for disposition.
But aren't we only concerned about a final order in Madison's case because that's the child with the severe abuse finding? I mean, aren't we only worried about that case being final?
Well, it depends if you want to read into the orders, which I don't think you can. It's not a final order because the second order clearly says the first one is rescinded. And if the first order as to Madison is rescinded, then it does not dispose of the case. And they still have to have another hearing on that. If you rescind an order, it's wiped off the books.
So
And-
this order was entered about 3 years ago.
Right.
So you're telling this court that there's some disposition hearing that is yet to happen, even though under the juvenile rules,
Right.
a dispositional hearing would have to happen within
My
what,
client is
15
not the
days.
petitioner in this case.
Yeah.
The Department of Children's Services has access to all things, and if the department's asking you to assume that it was dispositional and it was a final order, I don't believe this court can do that. These statutes are in derogation of the common law. Parents have a right to their children, but the state has set up certain requirements and criteria as far as when children can be taken from their parents and when their rights can be terminated. And it's the state's responsibility to prove those criterias, not to ask the court to assume that those criteria are present, and the state has failed to do that in this case.
All right, thank you, Mr. Pernick.
Thank you,
And
Your Honor.
General Adams, for your arguments. We'll take your case under advisement. That concludes the morning docket.